Now we have a case to take out of order this morning. I have private counsel present for Mr. Antonio Brown. Counsel, please approach the podium.
Warren Berkeley on behalf of Antonio Brown.
Good morning, Judge Goff. On behalf of Eric Schwartz, right on behalf of Antonio Brown as well.
Good morning, gentlemen. Good morning, Mr. Brown.
Good morning.
Mr. Brown, you're before the court this morning on count 1, burglary with battery. Count 2, burglary of an unoccupied conveyance, unarmed. Count 3, criminal mischief, $200 under $1,000, first offense. I find probable cause, and I will hear from the parties.
Good morning, Your Honor. Eric Linder on behalf of the state. Your Honor, if it pleases the court, I would like to present a witness to elicit some testimony.
Very well. Sir, will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes, ma'am.
Will you please state your name for the record?
Detective Stephen M. Regents, Jr.
Thank you, Detective. Mr. Linder?
Thank you, Your Honor. Detective Regents, who are you employed by and in what capacity?
City of Hollywood, and I'm currently in the Criminal Investigations Division and the Burglary Unit.
And what is your rank?
I'm a detective, sir.
And how long have you been a detective with the Hollywood Police Department?
Approximately 2 years, sir.
Okay. And you authored the arrest warrant that has been submitted to the court?
Yes, sir.
For Antonio Brown?
Yes, sir.
And in addition to the allegations contained in your arrest warrant affidavit, did you have an opportunity to speak to any of the witnesses to this case?
I did, sir.
And who would that be?
Manuel, which is identified as the trainer and manager of Mr. Brown.
And when you had an opportunity to speak to this gentleman, did he tell you anything to corroborate any of the victim's allegations?
Yes, he did. So yesterday I was speaking with him, trying to obviously get the defendant to surrender, knowing that he had the active arrest warrant. During that time, he said, we're working with him. He's close with me. He'll listen to me. We'll get him to turn himself in. Don't worry about it. We'll get him to turn himself in. He goes, who do you think the ones that pulled him off of me anyway?
And how did you interpret that? How did you interpret that statement?
I interpret it as he's the one that pulled Mr. Brown and the other co-defendant in this case off of my victim in this case.
Thank you. No further questions. Your Honor, if it pleases the court, if Detective Regents has some concerns with regards to safety of the community and flight risk, rather than going back and forth, if he could present that testimony now just to allow the proceedings to flow. And Your Honor, I think the court is aware of the state's position under the rules of procedure, as this is based on this hearing being non-adversarial, that the defense is not entitled to cross-examine the state witness at this time. If I could
discuss this, because I'm going to hear from both the state's position and I'm going to hear from defense counsel as to your concerns and what your recommendations are for bond and release conditions. Is the detective's testimony going to be something that's going to add to that or not? Because today's hearing, as we all know, this is only for first appearance purposes. This is not an adversarial hearing.
If I could clarify, Your Honor, the first part of the detective's testimony is strictly towards the factual allegations. Mr. Schwartz is correct. The court has found probable cause. As the court is aware, and Mr. Schwartz is aware, count 1 is a punishable by life offense. And as the court is aware under Esaza v. State, if the state is seeking for a no bond hold, which the state will be seeking a no bond hold, the court has to make a finding of proof evident or presumption great. The state is eliciting this testimony of additional factual evidence to seek with the intent of meeting that burden. And that is why, Your Honor, and as the court is also aware, under the rules, the state is allowed to present not just the evidence contained in the affidavit, but also testimonial evidence. And that is why I do not believe Mr. Schwartzreich is entitled to cross-examine this witness at this time. Your Honor, I'm going to object to relevant. If I can make a,
All right, hold on, gentlemen, hold on. I understand you're both here. I don't want you tag teaming on this. We need these proceedings to go smoothly. This is only a first appearance hearing. We have a large docket to get through. I understand the allegations are very serious, and I understand everything surrounding this case, but this is still a first appearance court, and we're not going to turn this into a full-on testimonial hearing where everyone's presenting evidence and making legal argument. It's not going to happen this morning.
Your Honor, and I would object to Mr. Schwartzreich's statement as irrelevant. The only relevance here is whether the state can legally present testimony at a first appearance hearing under Rule 3.133A3 under standard of proof. And I know the court is familiar with this rule. It clearly states that testimony under oath properly recorded may be presented for the court's consideration in making a non-adversarial probable cause determination. That is what the state has provided this morning.
Necessity in calling witnesses to establish or somewhat bolster that, because Judge Colbert has already indicated she found probable cause witnesses, that we would just like the opportunity to cross-examine those witnesses and ask their objection to relevance. Once there's already been probable cause, which Your Honor, Judge Colbert started out again.
And Mr. Schwartzreich is not replying to my argument that I'm relying upon ISAZA on a punishable by life offense, that I have to satisfy proof evident or presumption great in order for Mr. Brown to be held no bond.
And if that's the state's position, then we're asking for the opportunity to cross-examine. At this point, I'm not here for a full-blown hearing. The state wants to put on that testimony. We're asking for the opportunity to cross-examine.
Why don't I bring the three attorneys sidebar for a moment, please?